35 men and 1 woman wake up every dawn behind the razor coils of Parchman and Rankin County, staring at a calendar that could turn into a death warrant overnight. Tonight, we're walking cell to cell through Mississippi's entire death row roster. No politics, just the human stories, the crimes that put them there, and the ticking legal clocks that keep them alive. I'm Haprungs, and this is Final Sentence. Drop a comment telling us where you're watching from, and let's start the countdown. Abdur Rahim Ambrose. April 2013. The quiet Dalil backroads turned into a torture chamber. Prosecutors say Ambrose and 2 friends accused Robert Trosclair of swiping stereo gear, then spent 2 hours beating, stabbing, and finally strangling him. The jury saw photos of a living room floor painted with blood and heard chilling cell phone bragging. After less than 2 hours, they answered with death. Today, Ambrose's cert petition is exhausted. The U.S. Supreme Court shut the door in 2019, leaving only federal habeas tweaks between him and the gurney. He spends his days filing pro-se motions about jury instructions and Eighth Amendment claims, but even his own lawyers whisper the word final now. Bobby L. Batiste. Oktibbeha County, 2008. Grad student Andreas Galanis placed a roommate wanted ad. Weeks later, he was found face down, his skull crushed by a barbell. Police followed a bloody trail to Bobby Batiste, a construction worker with mounting debts and meth withdrawals. Batiste never denied swinging. He argued he'd snapped during an argument. The jury believed robbery was the motive, convicted him of capital murder, and cited especially heinous brutality to choose death. 16 years on, his appeals have circled technicalities: improper autopsy photos, juror church-going, mitigation limits, but each orbit ends in the same verdict. He now says traumatic brain injury fuels violent outbursts, hoping for a competency hearing before any execution date is signed. Devin Bennett. February 2001. Rankin County deputies answered a frantic 911. 10-week-old Brandon Bennett wasn't breathing. Autopsy: shaken, slammed, ribs snapped, skull fractured. The child's father, Devin Bennett, kept changing stories from "fell off the couch" to "I blacked out." Jurors needed just 90 minutes. They said the murder of a baby merited the ultimate penalty. 2 decades later, Bennett still claims innocence, casting blame on the boy's mother and citing junk science head injury testimony. In 2023, the state Supreme Court refused to reopen DNA arguments. There was none to test. For now, Bennett's cribside violence marks one of the row's youngest victims, and his file waits in federal district court limbo. James Billiot. Thanksgiving. Eve, 1981. Bay Street. Louis. Fireworks of screams erupted at the Kroll family home. Neighbors found Wallace Kroll, his wife, and their 14-year-old son bludgeoned by a hammer. Daughter Suzanne survived by playing dead. The killer, James Billiot, an ex-mental patient and Wallace's stepson, was arrested driving the family car, pockets stuffed with traveler's checks. At trial, he ranted about demons. Psychiatrists sparred over schizophrenia. The jury still returned death in 1982, making Billiot Mississippi's longest-serving condemned man after Richard Jordan. Appeals bounce between claims of psychosis and episodes of catatonia. Warden logs describe him conversing with invisible angels. The Fifth Circuit, however, says he understands why he's there, satisfying Ford v. Wainwright. Each year, his attorneys file a fresh insanity update. Each year, the courts decline. Joseph Patry Brown. Columbus, 1992. Convenience store clerk Tammy Criddle was closing when Brown burst in with a shotgun. Surveillance caught the blast that killed her in the stoop to grab $42 in cigarettes. Brown fled to Tennessee, where he bragged that "ain't no white jury gonna fry a black man for a stick-up." They did. Post-trial, Brown penned essays from death row claiming wrongful conviction. citing withheld plea deals for co-defendants and microscopic pellet pattern disputes. Advocacy groups spotlight him as a possible innocence case, but Mississippi courts label the evidence overwhelming. Brown tapes radio commentaries, urging viewers to see the human, while prosecutors push for an execution date once federal review ends. Xavier A. Brown, Jackson, 1992. Felicia Newell was lured from a club, driven down a levee, and executed. Witnesses said Xavier Brown feared she'd testify about a prior robbery. Brown's fingerprints on the gun, tire tracks, and a jailhouse confession persuaded jurors. On appeal, he argued police hypnotized a witness and that prosecutors struck black jurors. The Mississippi Supreme Court called the record clean. Brown now wrestles with an IQ claim. An expert pegs him at 70, flirting with Atkins v. Virginia protections. Prison logs note Brown's obsession with chess and gospel singing. Guards say he rarely speaks of the crime, only of God's timing. That timing could crystallize once his retardation petition is decided. Anthony Carr. Clarksdale woke to horror on January 24, 1990. George, Bobby Joe, 12-year-old Charlotte, and 9-year-old Gregory Parker, all shot execution-style in their farmhouse. Police arrested Anthony Carr and Robert Simon Jr. hours later, weapons still warm. Carr's trial revealed a burglary-turned-massacre. Jurors wept, yet voted death unanimously. For 35 years, Carr has filed petitions. Ineffective counsel, suppressed fingerprint experts, fetal alcohol disorder, but every court stamped them denied. Co-defendant Simon came within 4 hours of execution in 2011 before a chemical mix-up stay. Carr's date has never been set, but the Attorney General now hints both cases will move once new lethal injection protocols are finalized. Caleb Carruthers. March 2009, Lafayette County. What started as a small-time dope deal ended with the Clark family gunned down in their rural farmhouse kitchen. Prosecutors said 23-year-old Caleb Jermaine Carruthers emptied a .40 caliber pistol because Frank and Taylor Clark recognized him from high school. Mother Tanya survived a bullet that shattered her jaw and became the star witness who pointed from the stand. "That's the man who killed my boys." In 2011, jurors deliberated just 90 minutes before declaring the murders especially heinous and voting for the needle. Carruthers' appeals spin on a confession he claims was coerced after 36 hours without sleep and a head injury that doctors say lowers impulse control. The Mississippi Supreme Court tossed that argument in March 2025, and the U.S. High Court refused to bite. He now files typewritten motions about racial bias, but Attorney General Lynn Fitch has already petitioned for an execution date, signaling Carruthers could leapfrog others once the federal clock runs out. Inside Unit 29, he paints sports logos and tells guards, "I'll walk to that chamber like a man soon." Lisa Jo Chamberlain. In 2004, a dilapidated Hattiesburg rental became the scene of an almost cinematic horror. Prosecutors said Chamberlain and boyfriend Roger Gillett beat, suffocated, and dismembered roommates Vernon Hewlett and Linda Heinzelman after a fight over meth supplies, stuffing the remains into a freezer hauled 900 miles to an abandoned Kansas farmhouse. Detectives opened the lid weeks later to the smell of decay and the start of a cross-country capital case. At trial, the state portrayed Chamberlain as the planner who joked about road tripping with cold cuts. A Forest County jury agreed and returned death, making her the first Mississippi woman condemned since 1940. Her appeals hinge on whether jurors saw gruesome photos too many times and whether her lawyer's meth addiction sabotaged closing arguments. In 2024, the Fifth Circuit upheld the sentence, but 2 judges lamented gender bias in sentencing statistics. Chamberlain spends 23 hours daily in segregation at the Central Mississippi Correctional Facility, writing poetry about redemption and filing pro-SE motions that argue a firing squad option violates equal protection. Execution dates remain unscheduled. Ricky Chase. On Christmas Eve, 1985, furniture worker Johnny Buckner opened his Pontotoc County door and was stabbed 33 brutal times for the $140 in his wallet. Ricky Chase, then 19 and AWOL from a Louisiana work camp, was arrested the next day driving Buckner's truck with blood on his boots. The jury heard confessions recorded after Chase asked whether Satan could help him escape. They chose death, citing the cruelty and holiday timing. Chase later embraced evangelical Christianity and changed his middle name to Alpha Omega, claiming demons drove the murder. His appeals center on untreated bipolar disorder and an IQ hovering near 70. But in 2023, the Mississippi Supreme Court ruled those tests unreliable. A clemency petition argues life parole would cost less than a nitrogen chamber. For now, Chase mentors younger inmates in a prison Bible study and paints murals of Revelation's final battle. If the Attorney General's recent push for older cases succeeds, Ricky Chase could be among the first offered a choice between lethal injection and hypoxia, a decision his lawyers call theologically ironic. Tony Terrell Clark. June 2017, Madison County. 13-year-old Caleb Powell's summer job stocking a family-owned bait shop ended when 2 shotgun blasts tore through his chest. Surveillance video showed a masked man emptying the till, but a single slip, a visible wrist tattoo, led deputies to 26-year-old Tony Clark. At trial, jurors watched frame-by-frame footage and heard ballistics tie Clark's Mossberg to the crime. The defense claimed mistaken identity, but the tattoo matched. Deliberations lasted 59 minutes before adjourning forever. Clark's direct appeals focus on Batson violations, arguing black jurors were struck for flimsy reasons while white churchgoers stayed. In August 2024, the state Supreme Court ordered limited discovery, yet left the death verdict intact, calling errors harmless. Federal lawyers now probe Clark's childhood lead exposure and possible ADHD to craft an Eighth Amendment claim. Meanwhile, the boy's parents attend every hearing, wearing T-shirts that read, "Justice for Caleb." If Clark loses in the Fifth Circuit, the Attorney General has signaled he could become Mississippi's first Gen Z execution, a fact activists say would thrust neurological science onto the national stage. Charles Ray Crawford. Christy Ray's 1993 kidnapping still haunts Marshall County. An autumn night, the 19-year-old vanished from her front yard, was assaulted in a cornfield, and left partially buried alive. Within hours, deputies arrested neighbor Charles Ray Crawford, a recently paroled rapist whose shoe prints matched tracks beside Christie's body. A 1994 jury cited the prior rape and the sadistic nature of the crime when it voted for death. 3 decades later, the case teeters between medical science and retribution. Crawford insists repeated head injuries and epilepsy erased memory of the attack, arguing he cannot form the culpable intent required for execution. In November 2024, the Fifth Circuit rejected that claim. Dissenters called the majority clinically oblivious. Undeterred, Attorney General Lynn Fitch asked the Mississippi Supreme Court to set an execution date, sparking petitions from brain injury advocacy groups. Meanwhile, Crawford undergoes EEG monitoring at Parchman, hoping abnormal spikes will sway the U.S. Supreme Court. If the High Court denies review, he could face Mississippi's firing squad option, a prospect his lawyers say would render the 1993 violence grotesquely symmetrical. David Dickerson. Valentine's Day, 2012 in rural Copiah County ended with police body camera footage of Dickerson, shirtless and spattered with blood, surrendering beside a burning SUV. Inside lay Paula Hamilton, his former girlfriend and mother of their daughter, shot once in the chest and twice in the head. Prosecutors framed the murder as domestic terrorism. Dickerson kidnapped Hamilton after a visitation dispute, forced her to drive into the woods, and executed her. The jury watched a chilling cell phone video Dickerson filmed, barking at Hamilton to beg for her life. They voted death in under an hour again, citing torture and kidnapping. Appeals claim counsel failed to present PTSD from Iraq War Service and brain scans showing shrapnel scars. In April 2021, the Mississippi Supreme Court denied relief, concluding mitigation evidence would not outweigh brutality. Dickerson, now 55, files handwritten dreams to federal court, insisting parole-eligible life could let him mentor at-risk vets. The Attorney General's office calls the case priority once lethal injection drugs are secured, meaning Dickerson's PTSD arguments may soon face the ultimate stress test before federal judges. Leslie Bio Galloway III, Gulfport teenager Shakelia Anderson disappeared on a July 2004 night. Her burned, beaten body was found days later off Highway 15. DNA on a cigarette butt and witness statements steered investigators to 20-year-old Leslie Galloway, a former classmate. At trial, prosecutors said Galloway lured Anderson into his truck, raped her, doused her with gasoline, and ran her over to silence her screams. A Harrison County jury sobbed through autopsy slides, then chose death. Galloway maintains consensual sex, blaming an assailant for the murder. His appeals spotlight surrogate DNA testimony. The analyst who processed the samples never testified, violating confrontation rights. The Mississippi Supreme Court dismissed that claim in 2014 and again in 2024. The U.S. Supreme Court declined review later that year. Federal habeas lawyers now argue forensic flaws and racial bias in jury strikes. Galloway spends nights composing rap lyrics about the Firelight Road and tells reporters he fears nitrogen hypoxia more than lethal injection. With state remedies exhausted, prosecutors may soon push for an execution date that will test new gas protocols. Alberto Julio Garcia. July 2015, rural Jones County, 5-year-old J.T. Ramirez, still wearing torn blue pajamas, vanished during a birthday cookout. Searchers found him hours later in a ditch, strangled and sexually assaulted. Neighbors recalled seeing Garcia, the family's 28-year-old handyman, stumbling drunk from the property. When confronted, Garcia blurted a confession, later formalized in writing. He waived a jury and pled guilty, asking the judge to do what the Bible says. The court obliged, pronouncing death after a bare-bones hearing where even Garcia's mother begged for life. On appeal, he argued counsel failed to present brain damage from childhood solvent abuse. In 2023, the Mississippi Supreme Court said evidence of solvents would not have outweighed the brutality. Garcia's federal lawyers now emphasize his IQ of 68 and diagnoses of fetal alcohol syndrome, hoping to cross the Atkins v. Virginia threshold. He spends days drawing cartoons for his nieces, titling them Second Chances. Should the IQ claim fail, Garcia could become Mississippi's first execution based solely on a bench sentence since 1976, a precedent victims' advocates call long overdue. Willie Corey Godbolt. Memorial Day weekend 2017 turned Lincoln County into a war zone when Godbolt embarked on an 8-hour rampage again across 3 crime scenes, killing 8 people, including a sheriff's deputy, his estranged wife's cousin, and 3 children, during a custody dispute. Captured on body cam, Godbolt calmly told reporters he had tried to talk it out, but the police arrived. Jurors heard frantic 911 audio and saw a Facebook Live clip where Godbolt predicted he would die today. They instead chose death on 4 counts and stacked multiple life sentences. The Mississippi Supreme Court affirmed in 2023. The U.S. High Court rejected certiorari last month. Godbolt now argues ineffective counsel for failing to present childhood trauma and lead poisoning. Victims' families counter with public letters demanding swift execution. Inside Parchman, Godbolt mentors younger inmates in Christian rap, insisting he does not fear dying, only being forgotten. Attorney General Fitch lists the case among those ripe for a date once new nitrogen protocols clear review, meaning the man whose rampage shocked the nation may face judgment sooner than expected. Blade, Nathaniel Grayson. George County awakened to gunfire on April 3, 1996, when convenience store clerk Jeffrey Bird staggered into the road, fatally wounded by a buckshot blast. Surveillance video showed the clerk raising his hands in surrender before the firing. Witnesses saw a red Camaro fleeing. Inside, officers found Grayson and a 12-gauge shotgun. The state argued robbery. Grayson claimed accidental discharge during horseplay. Jurors deemed the act senselessly vicious and set death. Grayson's case gained attention after fellow George County prisoner Curtis Flowers won reversal for racial juror strikes. Grayson raised similar Batson points. In 2023, the Mississippi Supreme Court denied rehearing, calling evidence of bias speculative. Current appeals highlight adolescent brain science. Grayson was 18, and a borderline IQ of 71. He studies American Sign Language to communicate with a deaf pen pal, telling reporters the silence comforts him. Prosecutors, meanwhile, prepare to seek an execution date, arguing 29 years of appeals are enough. If the Fifth Circuit agrees, Grayson could test whether young adult neuroscience, still uncharted at the Supreme Court, will temper Mississippi's death machinery or mark another line crossed. Marlon Lataud Howell. Before dawn on a stormy spring morning, May 15, 2000, newspaper carrier David Purnell was shot dead at a Union County intersection, his wallet gone and papers scattered like confetti. Teen witness Jonathan Davis saw Howell's maroon Caprice speeding away. Police found the murder weapon under Howell's mattress. Prosecutors said Howell needed cash for crack. The jury convicted in 2001 and delivered death, citing a depraved indifference to life. Howell maintains innocence, alleging Davis fingered him to cut his own deal. Celebrities joined the cause after a 2014 Sports Illustrated article noted no forensic evidence placed Howell at the scene. In 2021, the Mississippi Supreme Court denied post-conviction relief, calling the witness credible. Federal attorneys now dissect cell tower data suggesting Howell's phone pinged miles away, arguing Brady violations. Inside Parchman, Howell tutors math and quotes Isaiah. "Come, let us reason together." Victim advocates counter that 2 decades of reasoning is enough. If the Fifth Circuit rejects the tower data, the Attorney General could finally set a date, pitting celebrity innocence campaigns against Mississippi's relentless calendar. James Cobb, Hutto III. Ethel Simpson, an 81-year-old church pianist from Clinton, loved stray cats and afternoon walks. On June 2, 2010, neighbors found her beaten, stabbed, and strangled inside her ransacked home. Blood spatter matched shoe prints that led detectives to Hutto, a handyman with prior burglary arrests. Prosecutors said he targeted Simpson for prescription pills. A 2013 jury took 90 minutes to sentence him to death. Since then, Hutto has challenged everything from lineup procedures to the sufficiency of fingerprint lifts. The Mississippi Supreme Court swatted each claim, most recently in July 2024, and the U.S. High Court officially denied certiorari this February. Federal petitions now allege fetal alcohol spectrum disorder and neurocognitive decline. Hutto teaches GED classes in Unit 29, telling students God has forgiven him even if the state cannot. Victim relatives attend every appeal, clutching Simpson's hymn book. With state avenues closed, prosecutors may seek an execution date once nitrogen hypoxia receives final protocol approval, placing Hutto among those who could choose between gas, injection, or the electric chair, and thereby write the method's next chapter. Kelvin Jordan. On a muggy August 1995 evening in Jackson, 16-year-old Codera Bradley was walking home from a basketball game when 2 men robbed and shot him. Ballistics and eyewitnesses pointed to Kelvin Jordan and accomplice Frontrell Edwards. A Hinds County jury convicted Jordan of capital murder in 1998 and sentenced him to death, citing prior violent felonies. Jordan's appeals raise mental retardation under Atkins, claiming an IQ of 66 and childhood lead exposure. The Mississippi Supreme Court rejected those arguments in 2005 but ordered hearings on ring-compliant sentencing factors. Subsequent juries reaffirmed death, calling the crime still unprovoked. In 2024, Jordan filed a successive petition citing advances in intellectual disability testing. The court called it untimely. Federal Habeas Counsel now seeks a neuropsychological evaluation using the AAIDD framework. Jordan spends hours translating Braille books for the prison library, insisting the Bible says God will open blind eyes. Victim relatives point to 3 decades of litigation and ask, what about Kodera's eyes? The Attorney General's office has not yet pursued an execution date, waiting for disability claims to resolve. Richard Gerald Jordan. The grandfather of Mississippi's death row, Jordan has waited nearly half a century for the state to carry out the sentence imposed in 1977. He kidnapped Biloxi banker Edwina Martyr, forced her to withdraw $25,000, then shot her in a cold forest clearing. Jordan confessed, expressing remorse, yet a Harrison County jury deemed the crime for money especially vile. Since then, his case spawned 4 resentencings, 3 death warrants, 2 commuted life terms, and 1 execution halted by lethal injection litigation. The saga ended May 23, 2025, when the Mississippi Supreme Court rejected his last rehearing, and Attorney General Fitch asked for a June 25 execution date. Jordan, now 79, suffers from heart failure and glaucoma. His lawyers argue executing a man of his age violates evolving standards of decency. Victims' kin reply that every Christmas since 1976 violated theirs. Jordan keeps a journal titled Borrowed Days, counting each sunrise as grace. Unless the U.S. Supreme Court intervenes, Unit 29 will wheel him to the gurney, making him the oldest person executed in state history ever. Jason Lee Keller. Biloxi's Nguyen Easy Pay was about to close on April 11, 2007, when Keller burst in wearing latex gloves and waving a .357 revolver. He demanded cash, then shot clerk Hatton Nguyen in the face as she complied, before fleeing with $300. Police traced latex fibers to Keller's motel room along with a pawned revolver receipt. Jurors took 90 minutes to convict and, swayed by surveillance, chose death the next day. An initial appeal claimed intoxication and fetal alcohol damage, prompting a 2015 resentencing where jurors again chose death. In 2024, the Mississippi Supreme Court remanded a narrow procedural issue, but upheld the verdict. Defense lawyers now challenge expert ballistics testimony. Keller, a high school dropout, studies for his associate degree through correspondence, insisting the Bible's thief on the cross gives him hope. Nguyen's family operates the store under a new name, donating proceeds to anti-violence programs. Prosecutors say once ballistic appeals finish, they will petition for a date, positioning Keller as a likely early volunteer for firing squad over lethal injection, citing quicker, cleaner perceived mercy. Stephen Michael Knox. On a bitter January 3, 1998 night in Amite County, 70-year-old convenience store owner Ella Mae Spears was found strangled with her own apron cords. Footprints in spilled motor oil led deputies to Stephen Knox, a former employee fired for theft. At trial, prosecutors said Knox returned to settle a score and robbed the register. Jurors saw autopsy photos of ligature marks and heard testimony that Spears begged for her life. They sentenced Knox to death in 2002. Appeals argue improper admission of prior bad acts evidence and ineffective counsel for failing to present childhood abuse. In 2023, the Mississippi Supreme Court affirmed, calling evidence overwhelming. Knox now files habeas petitions citing recent CO poisoning research that he claims impaired cognition. Within Parchman, he trains service dogs, stating, "If I die, at least let the pups live better." Victim relatives, still grieving, counter that Spears rescued strays too, making the irony unbearable. Should federal courts deny relief, prosecutors plan to seek an execution date aligned with the 20th anniversary of the crime, emphasizing closure for the rural community. Thongley, February 3, 2001, Bay Street. Lewis police responded to a grisly scene. Min-Hyu Tran, his wife and their teenage daughter bound, stabbed, and shot inside their ransacked home. Investigators traced a Rolex pawn ticket to 19-year-old Thong Lei, a Vietnamese immigrant who once lived with the family. Prosecutors argued Lei planned the burglary to steal $1,300, then executed witnesses. A 2002 jury convicted on triple capital murder and chose death. Lee's appeals challenge racial profiling, highlighting juror remarks about foreigners. The Mississippi Supreme Court upheld verdicts in 2005, but in 2024 the Fifth Circuit ordered limited Batson discovery. Meanwhile, Lee received support from Asian American rights groups arguing cultural bias-tainted evidence translation. Inside Parchman, he studies English classics, claiming Shakespeare proves anyone can transcend background. Victim relatives call the appeals cruel delay. He further alleges counsel ignored PTSD from refugee camps and malnutrition that, he argues, damaged impulse control. If Batson claims fail, prosecutors intend to seek an execution date that could test Mississippi's readiness to execute a foreign-born prisoner under new United Nations scrutiny. Willie Jerome Manning. Manning's legal saga reads like a law school exam on junk science. In 1994, a Oktibbeha County jury sentenced him to death for murdering Mississippi State students John Steckler and Tiffany Miller during a carjacking. Years later, FBI experts admitted their hair comparison testimony was flawed, and in 2013, Mississippi halted Manning's execution hours before midnight to permit DNA testing. Separately, Manning's second death sentence for the unrelated slayings of two elderly women was overturned in 2015, making him both condemned and exonerated at once. In 2024, Attorney General Fitch asked the state Supreme Court to schedule Manning's execution, arguing hair testimony errors were harmless. Defense lawyers counter with FBI letters admitting error, plus fingerprints on the victim's wallet matching another suspect. Manning, now 56, tutors GED math and writes spoken-word poetry titled Evidence. Victims' families divide over DNA testing. Some want certainty, others closure. The court has ordered fresh mitochondrial analysis due this summer. Its outcome could erase the last piece of physical evidence or cement Manning's date with nitrogen gas. Forensic watchdogs worldwide watch Mississippi closely. Eric Moffett. A Rankin County jury sobbed as prosecutors described how 5-year-old Kayla Jackson was raped and suffocated with a pillow in 2003. DNA under Kayla's fingernails matched Moffett, a neighbor hired to mow lawns. He confessed, then recanted, claiming detectives threatened false molestation charges against his mother. Jurors deliberated 80 minutes before choosing death. Moffett's post-conviction petitions focus on false confession science and claim the child died of positional asphyxia, not smothering. In 2022, the Mississippi Supreme Court denied successive relief, calling evidence overwhelming. Federal lawyers now cite new expert affidavits on adolescent injuries and allege trial counsel failed to present neurodevelopmental disorders. Within Parchman, Moffett spends days drawing cartoon angels he says watch over Kayla. Victim advocates argue the angels would rather see justice. Should habeas relief fail, Moffett could be among the first prisoners to face nitrogen hypoxia, technology critics say may resemble slow suffocation, the very act the state says he committed. He also argues prosecutors withheld a jailhouse informant's recantation, and ignored bruising inconsistent with adult force. Allegations now before the Fifth Circuit for briefing. Terry Pitchford. When Pitchford robbed Britt's grocery in Carroll County on October 19, 2002, he was 17. Owner Reuben Britt confronted him and was shot 5 times. A jury convicted and sentenced Pitchford to death in 2006. Years later, Supreme Court rulings limited juvenile death sentences, but Mississippi courts held Pitchford turned 18 before trial, keeping him eligible. In December 2023, a federal judge overturned the sentence, citing racial discrimination in jury selection by notorious prosecutor Doug Evans, ordering a new trial within 6 months or release. The state appealed, and meanwhile, Pitchford remained on death row, technically without a valid sentence. In January 2025, the Fifth Circuit stayed the release order, scheduling argument for autumn. Pitchford reads philosophy and tells reporters he forgives Evans. Victim relatives, exhausted, fear a retrial will reopen wounds. If the appeal reinstates death, Pitchford could become the rare prisoner executed after a federal reversal. If it fails, he may walk free, highlighting how one prosecutor's pattern can upend decades of certainty. Experts report new IQ tests at 69, brushing the Atkins intellectual disability line. Stephen Elliott Powers. University of Southern Mississippi student Beth Lafferty's 1998 disappearance sparked massive searches until her bludgeoned body was found near a Hattiesburg creek. Acquaintance Stephen Powers, then 20, was arrested after blood in his truck matched Lafferty's DNA. Prosecutors said Powers kidnapped Lafferty from campus, drove to the woods, and beat her with a tire iron when she resisted assault. A 2000 jury took 84 minutes to choose death. Powers insists another man used his truck and that he confessed under sleep deprivation. Appeals claim ineffective counsel for failing to present alibi ATM footage. The Mississippi Supreme Court affirmed in 2022. A cert petition is pending. In prison, Powers sculpts model ships, naming them Second Wind. Lafferty's sorority sisters maintain a scholarship in her honor and file amicus briefs urging swift execution. If the Supreme Court denies review, Powers could face a fresh execution date, and Mississippi may witness its first lethal injection under the new single-drug pentobarbital protocol. His latest filing argues mitochondrial DNA techniques exclude him from hairs on Lafferty's jacket, warranting an evidentiary hearing and force Mississippi to reconsider proportionality. Timothy Robert Ronk. Biloxi homeowner Stanley McKinley returned from vacation on July 17, 2008, to find his house burned and roommate Charles Gordon missing. Firefighters discovered Gordon's body. He had been stabbed and stripped of jewelry. Witnesses saw Ronk pawning Gordon's watch the next day. Prosecutors argued Ronk robbed Gordon to fund an OxyContin habit and torched the house to hide evidence. A 2010 jury deliberated 90 minutes, returning a death sentence. Ronk's appeals claim the fire scene was mishandled, pointing to an alternative suspect with gasoline on his boots. In January 2025, the U.S. Supreme Court declined review, leaving federal habeas as his last avenue. Ronk studies Catholic theology, telling pen pals he hopes for last rites, not clemency. Victim relatives rebuild the house yearly as a memorial bonfire. With cert denied, the Attorney General may soon seek a date, and Ronk has signaled he would select nitrogen gas over injection, saying smoke taught him fire can purify. Defense experts diagnose severe schizoaffective disorder, arguing delusions about demons influenced both the stabbing and symbolic arson, significantly mitigating culpability. Robert Simon Juder. On February 2, 1990, Walnut's Parker family, parents Carl and Bobby Joe and children Gregory and Charlotte, were bound, tortured, and shot before their home was torched. Simon and co-defendant Anthony Carr were arrested hours later, still carrying the victims' weapons. Prosecutors called the massacre the most heinous in Mississippi history. Jurors agreed, sentencing both men to death. Simon came within 4 hours of execution in 2011 when a dispute over physician credentials halted the injection. Since then, he claims amnesia from a 1999 prison beating and argues he is now incompetent to be executed. The Mississippi Supreme Court ordered evaluations in 2023. Experts found malingering, yet dissenters questioned methodology. Attorney General Fitch requested a new execution date in early 2024, but the court awaits further briefs. Simon spends days carving chess pieces, leaving the king unfinished, saying it reminds him life can stall. Victims' relatives, 3 decades older, still attend hearings, determined to see closure before their own candles burn out. Defense lawyers cite lead poisoning, head injury, and PTSD from foster homes to contest competency. Slide Wendell Smith. Liquor store owner Johnny B. Smith, not related, was closing up in Sidon on November 7, 1992, when 3 rounds ended his life. Eyewitnesses saw Clyde Smith flee with cash and whiskey. Ballistics tied the bullets to a revolver hidden beneath Clyde's mattress. A 1993 Leflore County jury chose death, citing prior armed robberies. Smith says he was framed by a jealous cousin. Prosecutors point to surveillance stills showing his distinctive limp. Appeals allege juror misconduct after one member browsed a Bible during deliberations. The Mississippi Supreme Court dismissed that as harmless in 1998. Smith has since argued aging witnesses recanted under hospice care, but affidavits were deemed hearsay. He volunteers in the prison barbershop, giving free haircuts until God cuts mine. Prosecutors have not yet sought an execution date, wary of the recantation claims, but victims' kin say every haircut is borrowed time unless justice is finally poured. New ballistic testing with 3D microscopes is underway, and defense hopes microscopic toolmark discrepancies will open the door to a rare innocence hearing in federal court next year. Roger Eric Thorson. On March 4, 1987, Thorson kidnapped ex-girlfriend Gloria McKinney after a breakup, drove her to a Harrison County bayou, and shot her twice in the head. Locals heard screams and saw Thorson speeding away. He was arrested hours later. A 1988 jury weighed kidnapping and prior assaults, returning death. The case endured mistrials, Batson hearings, and multiple appellate remands. Thorson argues he suffers bipolar disorder and that trial counsel ignored family abuse history. In 2023, the Mississippi Supreme Court denied his 15th post-conviction petition, stating, "Finality must come." Thorson, now 68, paints seascapes of the very bayou that witnessed the crime. Victim relatives hang replicas in their living rooms, saying they prefer closure over art. Prosecutors may seek an execution date once previous Batson litigation in similar cases concludes, positioning Thorson as a case study in death row longevity, nearly matching Jordan's 4 decades. Defense teams recently filed MRI scans suggesting frontal lobe lesions tied to industrial solvent exposure during shipyard work. Evidence they argue could persuade courts his impulse control was biologically compromised significantly and severely. Justin Underwood. Virginia Ann Harris vanished on a rainy September 4, 1994 drive to pick up medicine for her sick child. The next morning, her body, shot 4 times, lay near a cattle gap outside Flora. Police focused on Underwood after finding Harris's pager in his truck. Jurors convicted in 1995, and testimony about a prior purse snatching sealed the death sentence. Underwood maintains Harris willingly met him and that another man followed. The Mississippi Supreme Court affirmed in 2012, but in 2021 denied a new innocence petition alleging ballistics mismatch. Underwood's federal filings now present enhanced 3D imaging suggesting different rifling. He studies horticulture, growing tomatoes in plastic buckets along Unit 29's razor fence. Victim relatives drive past those vines en route to hearings, calling the site mocking. If courts accept new ballistics, Underwood could win a retrial. If not, prosecutors plan to request nitrogen gas, a method he says frightens him more than bullets. He also argues a false jailhouse confession was secretly taped, violating Miranda, a claim the Fifth Circuit will address during upcoming winter arguments. Allendale Walker. Kanya Rebecca Edwards, 19, left a Jackson nightclub on April 21, 1991, and never returned. Hunters later found her burned body in rural Rankin County. She had been raped, strangled, and stomped. Witnesses placed Walker's truck near the scene. An accomplice testified Walker boasted about making her scream like a movie. A 1993 jury convicted and imposed death. Walker claims childhood mercury exposure caused tremors and blackout violence. The U.S. Supreme Court declined review in 2021 after Mississippi courts dismissed those arguments. Current federal filings include PET scans showing frontal lobe hypometabolism. In prison, Walker makes origami cranes, mailing them to victims' advocacy groups with apologies. They return them unopened. Prosecutors, meanwhile, say Walker's case is execution-ready once litigation over lethal injection transparency ends, which could put him next in line behind Jordan. He further alleges that jurors saw gruesome autopsy slides on a projector larger than allowed. In flaming passion, dissenting state justices agreed but called error harmless. Defense hopes that photographic evidence standards evolving nationwide will finally crack open a resentencing and force Mississippi to reconsider proportionality. Derek Demond Walker. On July 17, 2001, career counselor Charles Richardson invited Walker, 19, to discuss job prospects at his Jackson home. Prosecutors say Walker pulled a pistol, demanded money, then shot Richardson in the head and set the house ablaze. Walker surrendered 2 days later, claiming accidental firing. A 2004 jury watched surveillance of Walker buying lighter fluid and chose death. Walker's appeals dispute gunshot residue tests and allege jurors saw inflammatory church banners outside the courthouse. The Mississippi Supreme Court rejected those issues in 2016. Current habeas filings argue schizophrenia, citing records of audible hallucinations since adolescence. Walker mentors youth through letters, warning fast money burns. Victim relatives attend hearings wearing lapel pins shaped like flames. If courts deny relief, Walker could be Mississippi's first execution after a purely circumstantial arson conviction, a point legal scholars say will shape debates on fire forensics. His attorneys also highlight new NFPA guidelines undermining the accelerant pattern analysis used at trial, asserting flashovers could explain irregular burn marks that prosecutors framed as deliberate arson and thus undercut the element of malice. 35 names, 35 clocks ticking in 2 quiet cell blocks. Whether you see justice, tragedy, or something in between, these stories belong to Mississippi until the final warrant is signed, or tossed aside by a higher court. If you want deep dives into any single case, hit subscribe and let us know which name you want next. I'm Duatiakis, and this was Final Sentence. Until next time, stay safe and stay curious about the system done in your name.